number 88, matter of Peyton versus New York City Board of Standards and Appeals. Counsel?
Good afternoon, Your Honor. Jonathan Popolo for Appellate Board of Standards and Appeals.
Counsel, we're having difficulty all around, not just with you, sir, hearing through the mask, so if you could try to keep your voice up. Thank you.
Certainly, Your Honor. Good afternoon, Your Honors. Jonathan Popolo for Appellate Board of Standards and Appeals. I'd like to reserve 3 minutes for rebuttal.
3?
Yes.
Yes, sir. You may proceed.
Should I proceed with my argument?
Yes, sir.
The Appellate Division's decision should be reversed. Rather than deferring to the BSA's practical application of the zoning resolution's open space requirements, it imposed a restriction not found in the text of the resolution.
Counsel, could I just clarify exactly what the question before us is? And particularly given the way that the board seemed to limit the issue reviewed in its 2015 decision to whether the 2011 amendments changed the language of the text in any way so as that it would be different from how it was previously interpreted, or whether it resolved any ambiguity. Am I correct in that that's really the limited question before us, whether the 2011 amendments changed anything?
Well, certainly that was the basis for the BSA's 2015 resolution, that the...
And aren't we limited to the basis that the agency gave for its determination?
In a sense, yes. I mean, I think that it's in a way up to the court how broadly you want to dig, but I think that, and certainly I can speak definitely to the point that the 2011 amendments did not alter the relevant provisions of the zoning resolution in a way that would have compelled a different result in 2015. If anything, the fact that the City Planning Commission kept intact, was aware of the BSA's interpretation of the open space requirement in 2009 and did not do anything to that particular definition in 2011, supports the notion that the 2011 amendments were not intended to change that.
So, if one were to see this as a question of pure statutory interpretation, I'm not saying I see it that way, but if one were to see it, how does the agency come to have any expertise that we should be looking at or giving deference to?
Well, I think you have a situation where the operative text is not clear and unambiguous. It doesn't inexorably require that open space be universally accessible to every resident on the mainland.
I'm just going to remind you what the chief said, the acoustics are such with the
Certainly.
mass and everything, that I need you to just keep your voice up.
Certainly, Your Honor. Nothing in the text requires that open space be universally accessible to every resident on a zoning lot, even if they do not live in the building containing the open space in question. And given the sort of inherent ambiguity there, the question becomes...
What is the ambiguity? I'm a little confused by that.
The ambiguity is it doesn't, there's 2 points. The definition itself on its face doesn't specify that. It could be read in a variety of ways, and it also didn't anticipate...
Well, point me to the ambiguity that you're relying on.
The ambiguity is in the meaning of what all persons occupying a dwelling unit or a rooming unit on a zoning lot means.
And the ambiguity is what?
The ambiguity is that could be read, that the first department read that as unambiguously requiring that every resident on the zoning lot, that it be accessible to and usable by every resident on the zoning lot, or perhaps, all persons occupying every dwelling unit or a rooming unit. The other end of the
So it says a person, or a, right? It doesn't say every.
correct, Your Honor.
Right, so taken literally, what would A mean in that context?
I think taken most narrowly and literally would mean at least one dwelling unit.
So, but that doesn't make, that's not logical, is it, that that's what they meant, right?
No, so, I mean, I think the BSA has interpreted it in a sort of more practical manner to, and what they believe is a more equitable manner, to allow some open space on a zoning lot to be reserved for residents of only one building, as long as the residents of every building have at least the minimum amount of open space that they would be entitled to if their building were on its own zoning lot.
But is that word part of the ambiguity? And are you also looking at it in the context of when the law was amended to allow for multi-building and
Correct.
owners?
It created certainly a problem of application that wasn't anticipated in 1961.
I see the problem in application. I'm struggling here in an ambiguity in the statute that would allow us to reach the underlying issue of how much deference we should give to you.
I think the ambiguity is, in a sense, it's sort of the negative of the fact that it's not clear and ambiguous. It doesn't clearly and ambiguously say all residents on the zoning lot, so it's a question of how do you interpret the language of occupying a dwelling unit or a rooming unit on the zoning lot.
Counsel, assume, just for purposes of my question, and putting aside Judge Stein's first question on if there's really a narrow issue before us, but assume it's clear, and assume it was misapplied in the case of 808 Columbus, right? What would the effect of the prior determination, even assuming it misapplied the rule, be on this application? Would your argument be that in some way you can't re-argue the square foot total for purposes of the new application, or do you concede that that has to be done each time independently?
Well, there's no dispute in this case, Your Honor, as to the actual total square footage. It's a question of whether the roof gardens on top of at 808.
Right, and in the prior decision, they included that 42,000 odd square feet, right? For 808 Columbus.
Correct.
So now you come in, there's a new building, they come in again, that determination has been made, and my hypothetical, assume it was clearly erroneous. It was a misapplication of a clear rule. What would the effect of the prior determination be on this application?
It might still be binding. I guess what I'm struggling with is the sort of clearly wrong when there's been...
Assume it for
assuming-
purposes of my
Okay.
question. I know you're not conceding it, but assume it just for purposes of this question.
That, assuming for purposes of argument that the 2011 amendments did clearly...
No,
change-
that
no.
at the time they made the determination, it was wrong. They just misapplied the rule. It was clear they made a mistake.
They might not be, I mean, there are site-specific issues here that there's there might be a reliance issue for the persons who, made plans based on that. I think certainly if you were applying it in a different arena or something, they would obviously have to apply the correct interpretation.
Well, let me see if I can put a point on it a little bit differently. Suppose you have a zoning lot that is out of compliance with the open space requirements, and somebody wants to erect a structure on it that is exempt from the open space requirements. Do you have a policy about that?
Not that I'm aware of, Your Honor.
Thank you, counsel. Counsel?
Philip Carmel, on behalf of the landowner, PWV Acquisition, may it please the court. Let's start off with the question.
Mr. Carmel, excuse me for interrupting. Would you like rebuttal time, sir?
No, thank you. Let's start off with the question of what was the rationale of the BSA, and therefore what's the legal issue before the court. I think you have to look at the 2015 BSA decision in the context of its 2009 BSA decision. In 2015, They said in 2009, we determined that these rooftop gardens were open space. In 2015, they said there's no reason to re-examine our earlier 2009 decision. So when looking at the rationale of the agency, I think it would be fair to look at the rationale that it articulated in both 2009 and 2015. In both determinations, they held the same thing, which is that these rooftop gardens are open space. In terms of the issue of ambiguity, is there an ambiguity in the statutory language? The answer is yes. If you look at the provision that the challengers are relying on in isolation, it is ambiguous, and I'll explain why. But it's more ambiguous if you look at it in the context of other provisions in the zoning resolution that also apply to open space. If you look at the provision in isolation, it's ambiguous because the word all modifies resident. It does not modify the word dwelling unit. What modifies dwelling unit is a dwelling unit. And you will have many circumstances where there are adjoining buildings, each with a rear yard, and the rear yard will be counted as open space if that area is accessible to the residents of the building for which it is the rear yard. I think I have a diagram of that in my brief. So open space, for an area to be open space, it has to be accessible to residents of a dwelling unit. It does not need to be accessible to the residents of all the dwelling units.
So that would mean, under that reading, that as long as it's accessible to one apartment has a roof garden, that counts as open space. Because it's a dwelling.
That is correct, Your Honor. That is a...
Wouldn't that just be an absurd reading that isn't really creating any ambiguity? Because could they possibly have meant that? That it's open to one apartment. I have a garden on my apartment, and that counts as open. I have a 42,000-foot roof area on my apartment, and that counts as open space for the entire lot.
That is a literally correct reading of the statutory language. It does not say all dwelling units. It says a dwelling unit.
It says a dwelling unit on the property, on the zoning lot, right? It says is accessible to and usable by all persons occupying a dwelling unit or a rooming unit on the zoning lot. So your reading would be any one unit on the zoning lot as opposed to a unit that exists on the zoning lot, has people in it, they have to have access, which seems to be the clear meaning there.
One or more dwelling units would be sufficient. That's an ambiguity in the provision in isolation. But that's
So
not
are you
the way...
saying- I'm sorry, yeah, maybe I'm interrupting you prematurely. You're not saying that's the way you read it. You're saying, but that creates an ambiguity?
That is an ambiguity.
Okay.
But this court does not read statutes by just looking at one phrase in isolation, out of context from the rest of the statute. If we look at other provisions of the zoning resolution, it creates a further ambiguity. For example, we can have open space in an inner court, which would not be accessible to other buildings on the zoning lot.
Why not?
Well, because you'd have to travel through someone else's residential building to get to it.
But even in this building that you want to build here, you have space on the roof where I think is accessible to everyone on the zoning lot, isn't it?
No, there's no space on the roof. That's a very confusing aspect to the record, Your Honor. What they talk about in this record as roofed open space is actually open space underneath a portion of the nursing home building. So there's
the
a
point
roof
being, I
above
think
the building.
that
It is at ground level.
If you have a courtyard, you have to have access. If you have a roof, you have to have access. It just depends on how you make the access. You can allow public access. It just wouldn't be a usual thing you would expect. But if it was required under the zoning laws, you could have access to an inner courtyard. You could have access to a roof by a different entrance. I mean, it doesn't create an impossibility. I'm even unclear how it creates an ambiguity.
It's suggestive. But there's more, Your Honor. Let's look at the one provision of the zoning resolution that actually talks about accessibility for rooftop open space. It's part of the definition of open space, and it says that where there's rooftop space, it must be directly accessible by a passageway from a building. It doesn't say from all the buildings on the zoning lot. And there are other practical considerations here. I think that this is a good example where,
So if it says a building, what meaning does that have, that it's a building as opposed to the building?
a building on the zoning lot. It doesn't require access from all the buildings on the zoning lot. I think if we look at,
Well, it says a building, yard, court, street, right? I mean, isn't a fair reading of that to mean that people have to be able to get to it, not which people have to be able to get to it?
it must be, this is the statutory language, it must be directly accessible by a passageway from a building.
Or a yard, or a court, or the street. That's the statutory language.
Not in the portion of the statute that I'm relying upon. What I'm relying upon is,
ZR 1210, little C, I think.
it's C3. It says, this is the portion that talks about rooftop open space. I think Marjorie Perlmutter is the chair of the Board of Standards and Appeals. She is a very experienced zoning lawyer, and she's also a registered architect. She's an expert in New York City zoning. And I think something she said at page 285 of the appellate record is quite relevant. She noted that there are many zoning lot mergers throughout New York City where it would be impossible for the residents of each building to have access to the rear yards behind the other buildings on the zoning lot. This is a totally impractical interpretation of the zoning resolution. And Chair Perlmutter recognized it as such. And it's not specifically required by the zoning resolution. There's no provision in the zoning resolution that addresses accessibility requirements for a zoning lot on which there are multiple buildings. It's simply not addressed. It's a gap in the language of the zoning resolution. And it's the type of gap that the Board of Standards and Appeals was created to address with its expertise.
But I'd like to go back to one thing Judge Stein was asking, that you don't interpret this statute, this law, to mean one apartment having access to the open space would be enough.
Your Honor, that's what I argued in my brief. Frankly, that's not what the Department of Buildings has held. The Department of Buildings requires that if there's open space associated with a building, that all dwelling units within that building must have access to that open space.
And that, to me, seems like answer C. Like, it seems like this provision could be read A or B. You say, yes, it could be read B as well. Isn't it that the agency then has to pick A or B? How can they pick C? Because C is a reading that you don't read that naturally. There are two, let's assume, there are two ways you could read this statute. Wouldn't we defer to the agency as to answer A or answer B because of their expertise? Why would we defer to them to answer C? They're just kind of making that up then. It's not in the statute. There's nothing about this particular building in the statute. So you have to have more than one apartment, and it has to be the building, but it doesn't have to be all? Why would we defer to that interpretation?
Well, there's a gap, and that's how the Department of Buildings filled the gap. I think that if there's an ambiguity, it must be resolved in favor of the property owner. That's very clear because zoning is in derogation of the common law. So if there's an ambiguity, it should be interpreted in my client's favor. And what the Department of Buildings has done is said, well, that would be a little bit ungenerous. So they've kind of added some additional requirements. Whether those additional requirements that it be accessible to all dwelling units within a building are in fact a permissible construction is actually not an issue joined by this case, because no one's arguing that the rooftop open space on 808 Columbus Avenue doesn't need to be accessible to all residents of 808 Columbus Avenue. That's simply an issue for a future case. Here, the BSA interpretation allowing the rooftop open space on 808 Columbus Avenue is consistent with a literal reading of the statutory language. There's a gap in the statute that the BSA filled in, and it's totally permissible. Another example would be parking. Parking lot, surface parking lot counts as open space. In fact,
Counsel, I'm sorry, I see your red light is on, Chief Judge, if I may. Would you answer the hypothetical question, if you remember it, that I asked your counsel about what if this, just assume, again, I know you dispute this, but assume this was an error, the 42,000 square feet determination. What effect would that have on this application?
I would argue, Your Honor, that the 2009 BSA determination cannot be collaterally attacked in this proceeding, challenging the 2015 BSA determination. And I would give you two rationales for that position. The first is what the provision of the New York City Charter that I've cited, subdivision 8 of section 666 of the Charter, which places limits on BSA reconsideration of earlier BSA determinations where there's been adverse reliance. The second would be a case of this court called EFS Ventures. EFS Ventures was a decision involving a site plan that was approved by a planning board. Then several years later, someone went back and said they wanted to change the site plan. And the planning board the second time around said, you know what we did the first time? We don't really think it was very smart because it lacked access to fire department vehicles. And this Court of Appeals said that earlier planning board decision cannot be collaterally attacked in a subsequent proceeding. The statute of limitations is run, the thing has been built, and it is unfair to go back and re-examine the earlier administrative agency decision. So I don't think they can challenge the 2009 BSA determination in this case. That should be accepted as bedrock. And the only issue, as the BSA framed it in its 2015 decision, is whether the 2011 key amendments changed anything, and it's very clear from the briefs that they did not.
Thank you, Counsel.
Thank you.
Counsel?
May it please the court, my name is John Lobear for petitioners respondents. I'd like to make three main points. First, the plain language clearly negates appellant's argument. Second, and its history and the history and purpose, as well as the plain language of the 1961 zoning resolution, negate their arguments. Second, the subsequent history, and in particular the 1977 amendment, doesn't help them at all. It did not first introduce multi-owner zoning lots. They've existed for some time before that, and it did not make common access untenable. Their historical account is not accurate. Third, there is no problem with multi-owner zoning lots, and with all due respect to Marjorie Perlmutter, this is a manufactured problem. In all the years since 1961, no one has ever asserted that there's never been an issue about people trying to get into somebody else's private backyard.
There's one other issue that I would like you to also address, and that is how, if at all, the 2011 amendments changed the definition of open space in the zoning resolution.
Okay, well, let me start out with that then.
Thank you.
So in our papers, we contended that the 2011 amendments were important because in its 2009 decision, the BSA relied only on two provisions, Section 2314 and 23142.
Well, what if I disagree with you that that's all they relied on, and we're looking at it today with a clear, a different lens, and that is, as we look at those amendments, can you tell me how they changed the definition?
Well, they did not change the definition of open space, but I would contend that the BSA, neither in 2009 nor in 2015, did the BSA ever refer to or rely on the definition of open space, nor could it have, for the reasons that many members of this court have already articulated.
Well, let me ask you another question. As I look at the two sections that we're talking about that were amended in 2011, they talk about how you calculate certain things, right?
Yes.
They don't talk at all about accessibility.
That's right.
And so I think the question that we're really focused on here is to whom does it have to be accessible? So how do those amendments inform us or change in any way whether the 2009 reading was correct or incorrect? How do those amendments change a determination as to accessibility?
Well, I would contend that appellants say that the 2011 amendments are irrelevant. So fine, they're irrelevant. For purposes of this argument, I can agree with that. So let's then look, what is it
But if that's true, then aren't we relitigating a determination that's already been made?
No, we're not, because that determination was only based on those two provisions that were amended. It didn't cite the open space definition in its support, nor could it have, because there's nothing in that definition other than a clear requirement that the open space must be accessible to all persons who are resident on the zoning lot. So what they did was they said, well, okay, that's what it says in the definition, but then in the part where it says how you calculate the open space, you can do that building by building. You have to do it building by building. So they said, well, since the method of calculation seems to be at odds with the access requirement, we're going to say that it only has to be accessible to the occupants of one building in order to be considered open space. So they did not rely on the thing that was unchanged. They only relied on the thing that was changed. They were wrong then, and they're wrong now.
So assuming they were wrong then, what effect would that have on this determination? Let's assume they were wrong. There was a challenge to that determination. It's finished. It's over. Now
Well,
you come in and you want to build they want to build a different building, and they want to use the numbers that were generated by that prior decision in terms of open space. Why should you be able to go back and revisit that earlier decision?
Because there's no collateral estoppel here for three different reasons. First, there's no...
Aren't you the same petitioners essentially?
I'm sorry?
That prior proceeding?
I'm sorry?
Judge Feynman's asking, are
I'm
you the
asking,
same
aren't you
petitioner?
essentially the same petitioners who brought the previous proceeding?
No. First of all, there is absolutely no connection, or anyway, only the most tenuous. I mean, I think one of the petitioners was an officer of the Park West Village Tenants Association, which wasn't even a petitioner in the first proceeding, and he was only an officer after that proceeding had concluded. So, and Maggie Peyton, who was the original petitioner, was, I believe, involved in that too, but they were not petitioners. So first of all, there's no privity. But secondly, leaving aside privity, even if you could argue privity, this is a different building, and the law has changed in material, very material respects, because the only basis that the BSA cited for its ruling in 2009 were the two provisions that were
But I'm saying
amended.
assume that 2009 was wrong, so it doesn't matter if the law has changed or it hasn't changed, so just assume they made a mistake. But each time the owner on this lot wants to build, you could go in and with a measure and measure the square feet of things that have already been determined and challenge the calculations? Like, on any basis, you can say, no, it isn't 130,000 square feet, really, it's 120, because we measured, and I bring in my measurements, and the square footage that you already measured and counted as open space for the prior application is different now.
Well, that's not this case, Your Honor. I don't
No,
know.
I know it's not this case, but
Yeah.
it's my question. So could you do that?
Could you challenge the square footage if they had gotten it wrong? I'm not sure about that. I'd have to think about
Because
that
isn't there
more.
kind of a
but-
policy reason not to be able to do that? Like that you can come in, you can drop a challenge, you know, that thing is already done, there's reliance in terms of, okay, now we're gonna come in with a new application, we wanna build this. No, we're gonna go back to square one and we're gonna remeasure everything, and the numbers may come out differently this time.
Well, I believe so. I believe you could challenge that again.
So basically, there's no finality.
I'm sorry? I mean, it's not the same parties, and it's not the same building. These petitioners may have a different interest from the...
So what if somebody had moved out of the, the other buildings? There's just a new resident, right? It's the same building or unit of which people had challenged the last time. But there's a new tenant, or there's a new owner of one of the units, right? So anytime there's a change in who's living there, that person can bring a new petition and a new challenge to anything that was found previously by the board?
To a different building?
Well, no, so you've got several buildings on this lot,
Right.
okay? And in 2009, certain residents of other buildings, not the one that was just built, or at that time, and now there's a new building proposed to be built, but the people already living on the lot, okay? And there are a number of different units in those buildings, right? And so I guess I'm just sort of following up on Judge Garcia's question. Are you saying that any time somebody moves out of one of those units and somebody else moves in and buys it from them, then that person can go back to the board and say, I think you made a mistake when you approved this last week or last year or 10 years ago?
Well, you can't go back and challenge what was done on 808 Columbus. We're not doing that because that building is built. It's grandfathered regardless. So whatever facts were found there presumably would be res judicata, but there wouldn't, and there would be a precedential effect. But there wouldn't be collateral estoppel if it was a different person. In this case, the people are not living, the people who are the petitioners here, I don't know, but they may not have been affected at all by 808 Columbus because this is a very large zoning lot, so they may live a lot closer to the new building proposed than to 808 Columbus.
So what you're saying is that a determination is made that space at 808 constitutes open space, but it only constitutes open space for certain people, not others?
No. So the determination that was made, what the BSA did in that case was it approved a particular application. It was an appeal from the grant of a building permit. So what the BSA did there was it denied the appeal for that particular building, and that allowed that building to be built. Now, if somebody else comes along and says, I want to build a different building, I mean, you know, we're very far from the facts of this case here, but you know, if they challenged the how many open, you know, whether they had measured correctly the number of square footage of open space, yeah, I think they could do that. They might have a heavy burden. It might be a tough road to hoe, but I think they could do that.
Let me ask you the question that I asked Mr. Popolo earlier.
Yeah.
Suppose, for the purpose of this argument, that the zoning lot is out of compliance with the open space requirement, okay? The prior decision was wrong. Let's assume that. The building they're proposing to build doesn't require any additional open space. So why can't they build that?
It does require additional open space. It doesn't add to the open space requirement, but the footprint of the building further reduces the amount of open space on the lot. That's why they're putting this open space underneath the building, because, you know, but that mitigates their.
They're still 10,000 feet short, right?
Yeah, they're still 10,000 feet short.
What if they weren't?
Right.
What if it was neutral? What if the building was space neutral, so that it takes up 20,000, but they have 20,000 fully accessible rooftop open space? Would that change your
If
answer?
it didn't add at all to the...
It's totally neutral.
Yeah, if it did not add to the non-compliance, maybe they could build it then. I mean,
doesn't that
I
undermine
don't know. Again, it's not this case, and I don't,
But then it seems like you'd still be in, under your theory, why wouldn't the answer be you'd still be in non-compliance? Because it isn't building by building, right? It's how much open space is on the lot when you put the building there.
I'm sorry, what?
That's not a good way to explain it, sorry. So if you put in a 20,000 square foot building, and the open space it's taking up, it's compensating for in that building. So it builds a 20,000 foot open space garden on the top, fully accessible. So it doesn't need to borrow, right, from wouldn't it still, the lot would not be in compliance. So on the theory, this is a new application, why couldn't you challenge the 42,000 foot prior?
Well, actually, that might come up in the next case, because I don't know if you looked at their proposal that's attached to their letter that they submitted a few weeks ago, saying, oh, well, now it's not only moot because they're not going to build this building, but now they found another way to circumvent the statute, and it might raise that very question. But we haven't really gotten to that yet. But I think, I mean, the question before the court here is whether they can count the open space of 808 Columbus. So if you're hypothesizing a building that doesn't require them to count the open space of 808 Columbus in order to be built, then yes, I guess they could build it.
The problem I have with that is you still need the 42,000 square feet on that new application to cover the entire lot, unless I'm misunderstanding something here. Isn't it? It's not building by building, right? So I build a building on this lot. The lot, it still needs to be in compliance.
The lot is still out of compliance, but it wouldn't be more out of compliance than it already is. So,
I see.
You know, arguably, I mean, I don't know. Again, this is the next case. Don't want to concede the next case that that's going to happen when they propose their new proposal. But if I may, I'd like to make a couple of points that actually I kind of, that maybe are not, I didn't have room to explain in my brief, but the 1977 amendment didn't change anything. I mean, I don't know if this is how, but what the 1977 amendment did is it changed the way when zoning lots are merged, it changed the way these arrangements are formalized. But even before the 1961 zoning resolution, there were arrangements so that multi-owner zoning lots could exist. And in fact, the Empire State Building was built pursuant to one such arrangement, whereby there were lease arrangements. They were called development rights leases. So if you had a low building nearby or an empty lot, you could lease it to somebody who wanted to build a tall building next door through a development rights lease. And the problem with that was that these leases were sometimes terminated, leaving unclear who had the development rights. Was it the lessor or the lessee? And there's a case called Newport Associates v. Solo, which I think Appellant cited. It's at 30 New York 2nd 263, which talks about this issue. It's a 1972 case. So the 1977 amendment, now being cited to justify what we would call overbuilding, was enacted precisely to protect. This is a quote from the City Planning Commission's 1977 report, that it was enacted to protect the city's interest in avoiding overbuilding, end quote, as well as to clarify the rights of all involved. So instead of linking buildings in a merged zoning lot through development rights leases, the amendment required that such lots would be created by a recorded declaration. So it changed the way these arrangements were formalized, but it wasn't that when in 1961, when the drafters wrote that an open space had to be accessible to and usable by all persons occupying a dwelling unit or rooming unit on the zoning lot, they were well aware that zoning lots could be merged through leases or other arrangements. And so there is absolutely no evidence in the record that this has ever created a problem, and the problem that Board Chair Perlmutter indicated, nor is there a gap about multi-building zoning lots. In fact, to the contrary, this provision was written precisely to encourage and to apply to multi-building zoning lots. There's a nice quote, which I have here somewhere, in the city's zoning handbook. It says, the 1961 zoning resolution, quote, favored an idealized configuration of tall buildings set in large amounts of open space, the tower in a park vision. This model was shaped to fit large urban renewal projects in which older buildings were raised, streets were demapped, and blocks were consolidated to produce superblocks such as Park West Village. That's on page 63. So, you know, that vision is totally negated by Appellant's interpretation of this language, and to say that there's nothing in the zoning resolution that affirmatively requires common access. I mean, you can say that till you're blue in the face, but the very provision that's at the heart of this case requires common access. If it's accessible to all persons, that means common access.
Thank you, counsel. Thank you.
Oh.
Counsel?
Thank you, Your Honor. I mean, there are numerous provisions in the zoning resolution that don't contemplate access to everybody on the zoning lot. I mean, it specifically included yards, which includes rear yards, which are the type of space that one would not normally think would be accessible to persons other than the persons living in the building that has the rear yard. It specifically included inner courts.
Counsel, would you address the argument that the 2009 determination was based solely on sections 2314 and 23142?
I don't think that's quite correct, Your Honor. I think that there were references in the Department of Buildings determination that this complied with the requirement that it be accessible to the, the occupants of a dwelling unit or a rooming unit. And the BSA adopted this, but I don't think you can say it's limited just to that. And I think that there is a sort of a structural principle in the zoning resolution that open space is tied to the floor area of residential buildings. I mean, it can be provided in different permutations, but ultimately, the requirement for open space, I mean, the calculation comes from the floor area in the residential buildings on the zoning lot. So there's this notion that it is connected to a residential building. I mean, the BSA is not pulling this out of nowhere. And I think what they're trying to do is, what they're there for. And then you have a zoning resolution that, cannot anticipate everything that's going to happen in the future. And the BSA is trying to forge, practical solutions to, difficult situations and unforeseen situations. And that we shouldn't tie their hands unless there's an explicit restriction in the zoning resolution. And here that restriction is not explicit.
Thank you, counsel.